So we can't hear you, sir.
Hello.
Yes, sir. Now you are audible. Good afternoon.
Good afternoon, sir. Yes.
Hello. Hello, students.
Hello, sir.
Yes, sir.
Yeah, we can hear you, sir.
Hello.
Yes, sir.
We can hear you loud and clear, sir.
Audible, sir.
Hello. Students, are you able to hear me?
Okay, so I can now send it back to that center. وهنا that is after.
Hello.
Yes, sir.
You are audible, sir.
Okay, just a minute. Okay.
Please continue, sir. Please. Sir, you have muted your line. Can you unmute?
If the design needs any modification, it's in draft.
Hello.
Yes,
You are
sir.
audible, sir.
Yeah,
Yes,
yeah.
sir.
Oh, very good, very good. System was muted. Okay. Shall we start our class?
Yes, sir, please.
Yes, sir.
Yes, sir.
Yes, sir.
Sir, can you change it to PowerPoint mode?
Slide. Just a second, just a second. Are you able to see PPT now?
Yes, sir.
Yes, sir.
Yeah. Shall we start now?
Yes, sir. Yes, sir. Please.
Yes,
Yeah.
sir.
Very good afternoon to all of you. Yeah. Very good afternoon to all of you. Once
Very
again,
good afternoon, sir.
Good afternoon, sir.
yeah, once again we are joining back to this business law classes. I hope by this time all of you are very clear what is contract. Do I need to repeat or shall we proceed forward? Okay. We can proceed.
Please proceed, sir.
Yeah. The last classes we discussed about what is a contract. Just 2-3 minutes I will go through that. Again we will proceed forward. Contract is essentially is an agreement. Okay. Contract has two parts. One is a set of two promises, one flowing from the offerer and the other from the acceptor. Because an agreement which is enforceable by law is a contract. A promise is an acceptable offer or proposal. When any offer is given, it is accepted, it can be called as promise. An offer or proposal is a promise of performance which is however conditional upon a written promise or an act forbearance receipt exchange for it. Whatever you have promised, if you are fulfilling that one, then it will be converted into a, after performance it will be a contract. So here you can see offer or proposal, then it will be accepted, that is acceptance. Then it becomes, when offer is accepted, it becomes promise. Promise becomes with the condition, if it is accepted both the party, it became agreement. Agreement which is enforceable law is a contract. So we have also discussed who are competent to contract, isn't it? Next, rules relating to agreement with a minor, we have already discussed. Then types of contract. Have we discussed types of contract last classes? Do you remember?
No, sir. No, sir.
Yes, sir, we remember.
So, we'll be discussing types of contract. You can see there are various kinds of contract. First is called as valid contract. What is a valid contract? It is an agreement which fulfills all the essential of enforceability and can be enforced by the either of the party at the courts of law. Is called as valid contract. That means a valid contract should have all the essential elements which is enforceable by law. Is a contract, and violation of this particular agreement, you can go to the court of law to take the action. So that is valid contract. Then next is voidable contract. An agreement which is enforceable by law at the option of one or of the other parties, but not at the option of the other or others. It is a voidable contract. For example, A at the point of pistol makes a B agrees to sell his bicycle for ₹500. Here B's consent is not free. It is forcible by some other person to accept the contract. That will be called as voidable contract. It is not valid contract, but because essentials of the contract is not, elements of contract is not fulfilled, because it is by force you are compelling the person to accept the contract. So this can be called as voidable contract. You can see what are the circumstances in which contract can be voidable. Like consents caused by fraud. By fraud, if you are taking the consent, then it can be called as voidable contract. You have signed the contract, all the elements are there. By fraudulently, by telling something wrong, you have asked the person to believe the person to the truth and he has accepted. That is called as voidable contract. Similarly, consent caused by coercion, by force, if you are, or by threat, if you are making a contract, that is also voidable contract. Consent caused by misrepresentation, by misrepresenting something. Suppose a person is not well, by the time you have misrepresented him and he is believed that whatever you are telling, that is correct. By thinking so, he has given his consent. That means it is you are misrepresented to him, so it can be called as voidable contract. Similar way, caused by undue influence. If you are giving any undue influence and getting signed, in many of the government organizations, they are giving bribe or something like that. Not only government, private organizations also. In many of the contract, you can see there will be something like some undue influence is put on the person to get the contract signed. So in that case, it can be called as voidable contract. Next is void contract. What is void contract? A contract which ceases to be enforceable by law. If it is ceased, the contract is ceased to be enforceable by law. Suppose yesterday something, the law was not enforceable or the contract was valid. Today suddenly government declares something that this kind of business is prohibited. So if you are entering such kind of contract, it's called as void contract. The circumstances in which valid contract transfer into void contract, when it can be a void contract. For example, contingent contract. Contingent contract to do or not to do something on the happening or uncertain future event becomes void when the event becomes impossible. Suppose you say that sun will, if sun will rise from the west, then I will pay. Such kind of thing is impossible to perform. So that is called as void contract. Repudiation or voidable contract. When a voidable contract is rescinded by the party at whose option it is voidable, the contract becomes a void. If the party who accepts the thing and on his behalf he declined to do that, then it can become a void contract. Subsequently impossible. A contract which becomes impossible to perform at its made becomes void. Subsequently illegality. Subsequently a contract becomes void, it becomes illegal after it is made. While making it was not illegal, but after it became illegal, then it will be a void contract. Another is illegal agreement. An illegal agreement is one which is forbidden by law, that is entered into with the intention of violating the law. In that case, it will be called as illegal agreement. If illegal agreement is illegal, then contract is not valid contract. For example, A agrees to steal furniture of B for a consideration of 1 lakh rupee. It is illegal and therefore it is void. It also attracts the penalty provision at the law it is violating. So this can be called as void agreement because agreement is not enforceable by law. It is an illegal agreement. So that will be a void agreement. Similarly, unlawful agreement. Agreement may be unlawful because it is a immoral, that is contrary to sound and positive morality as recognized by law. For example, cohabitation oppose public policy, that is contrary to the welfare of the state, as tending to interfere with the civil or judicial administration or with the individual liberty or citizen. This is called unlawful agreement. For example, bribing a public servant is illegal, that is contrary to positive law, being forbidden either by the statute law or common law. Hence, a line of demarcation needs to be drawn between the illegal and unlawful. There are two things, illegal and unlawful. Illegal means totally it is not accepted by the court of law, and something unlawful agreement means something public policy going against the public policy. So that is unlawful. Next is unenforceable contract. Contract which have all the essentials of enforceability but cannot be enforced due to certain technicalities like insufficiency of stamp, etc. are termed as unenforceable contract. So the contract where some technicality is there, some mistakes are there, it can be called an unenforceable contract until unless it is rectified. Like for example, government has decided this much stamp duty you have to pay. If you have taken the lesser amount of stamp paper and making the contract, that will be called as unenforceable contract. Next is express contract. It is one where the intention of a party is stated in words either written or spoken. It can be written, it can be oral also. Example, A goes to B's shop and asks him to supply 10 boxes at the rate of rupees 20 per box. B tells him that he is ready to supply the boxes at the mentioned rate. This is an express contract because they have expressed, orally they have expressed. The same intention of the parties may be expressed in writing, signed by both the parties. If that contract is written also, that can be called as express contract, or orally also it is expressed, can be acceptable. It's called as express contract. Another one is implied contract. The evidence of an implied contract is to be deduced from the acts or conduct of the parties. No exchange of words, either written or spoken, taking place, but the manifestation of their intention is inferred from their respective acts or conduct. I gave you the example. Suppose you are buying a bus ticket and getting inside the bus, you are taking your seat and traveling to the destination and getting down. You have just paid the fee, bought the ticket from the counter without expressing anything. That means it implies that the action which you are doing, you have bought the ticket, that means you are you have decided to travel to the particular destination. That's why you have purchased the ticket. So here no need to express to someone that I am going to travel to this place. You have bought the ticket, got inside the bus, and conductor has checked. You have traveled to destination without expressing anything. This means it implies that you have made a contract. It's a implied contract. Is it clear?
Yes, sir.
Next is quasi-contract. These are those obligations which are imposed by the Contract Act and do not arise from a consensus between the parties. Example, A tradesman leaves the goods at B's house by mistake. B treats the goods as his own. A is bound to pay B for them. The obligation is imposed by the law. So quasi-contract means somebody should not take advantage of others. For example, as I gave you, a tradesman, he leaves the good at B's house by mistake. He has mistakenly left he has visited to B's house, but mistakenly he has left the property there or back there. B treats the good as his own. He took care as if it is his own. Suppose some items are there which can be spoiled after 1 or 2 days. He might have kept it in the refrigerator, or ice, he might have bought ice or something, he has taken care as his own. A is bound to pay B for the obligation is implied by law. When A goes to B that please give back my goods, A says that I have spent this much for the maintenance. A is bound to pay to B, because this although it is not a contract, a pure contract, but somebody should not take the advantage of it. B, he has taken care of the property of your property by thinking as if it is his own. So A is responsible to pay the maintenance fee. For example, you have left by mistake your bike at your friend's house. You have forgotten. You have gone somewhere out of country or somewhere. After 1 or 2 years, you have come back. You have demanded that my bike was left here. Kindly give me my bike. And he says that I have taken care of your bike and I have paid this much amount for the maintenance. And you are supposed to pay the maintenance fee to your friend. So this is called quasi-contract. Another one is execute a contract. A contract where both the parties to a contract have discharged their respective responsibility by performing them. Both the parties, they have performed their duty. Whatever agreement is made, both the parties, they have completed from their side. That is called as executed contract. That means all transaction of cash sales are the example of executed contract. Cash sales means in the sense you have paid the cash and you have bought the item, you have taken it back. That means it has been already executed. Similarly, executory contract, it is one where one or both parties are yet to perform their respective promises. If one party is left, he has not done, suppose you have paid money, B has not given the goods to you, that means it is executory contract. B yet to be, he is yet to give the product to you. So only one party has performed his duty. Even both the parties have not, they have made agreement, both the parties have not done their duty, that means it is executory. It has to be executed from the both the side or either one side. So that is called as executory contract. Next one is called a unilateral contract. It is the contract where all the time when the contract is made, one party has already performed its obligation. It is one where at the time when the contract is made, by that time only one party has performed its obligation. The other party yet to perform. It is outstanding. That is called a unilateral contract because one party has completed his obligation. Second party yet to complete his obligation. It's called as unilateral because only one sided contract is completed. For example, A goes to a bus stand ticket counter and buys a ticket for journey. He has performed his duty under the contract. That means he has bought the ticket. A, he has performed his duty. That is to pay the scheduled fare. He has paid. But the bus authority yet to perform his promise. Bus authority, when bus will start, then you will travel to the destination. Authority is yet to perform his promise, that is of carrying him from point to another. This is a unilateral contract. One party, you have already paid a fee for traveling, but yet to bus has to start and to reach the destination. That is one party is left over. This is called unilateral contract. Similarly, bilateral contract. As against unilateral contract, a bilateral contract is one where at the time of entering into the contract, both the parties to the contract are yet to perform their respective promises. Both the parties, they have not done their obligation. It is like executory contract. So here both the parties, they have not done, it is a bilateral contract. You can say as executory contract also because both the parties have to perform their duty. As both the parties have not done the obligation, that's what it's called a bilateral contract. Now the important again thing is modes of discharge of contract. How will you come to know that contract has been discharged? That means contract has been completed. So a contract is discharged when the rights and obligations created by between the parties come to an end. That means the right to do something or obligation to do something is already over. It is end. Nobody has any rights or obligation to the act. or to the contract. It is over. Discharge or termination of contract means termination of the contractual relation between the parties to contract. So the termination of that, it is already completed. No one has to do anything else. The contract is over. That means discharge of contract. For example, how it will be? Contract may be discharged or terminated by any one of the following, who are by performance. Both the parties, they have performed their duty, performed their obligations. That means contract is discharged. That means contract is over. By consent of agreement, if the agreement, you have made a contract for the agreement period of some particular time, once the period is over, the contract is discharged. By impossibility, if subsequently, if there is any chances there, after that it is not possible. Suppose tsunami came in between, or some disaster has come, after that it is not impossible to do. So both the side, the contract is discharged, because due to natural calamity, everything is gone. Now it can be called as contract is discharged. You cannot say, you cannot go to the court of law, any of the party cannot go to the court of law that so and so has not performed his duty, because due to natural calamity, it is impossible to do now. Next is by lapse of time. If time period is over, after that you cannot say that still contract is there. Once time period is over, the contract is discharged. By operation of law, by some operation of law, by something is the law says that after so and so time it will be over. That means contract is over. There is a law of limitation, like limitation, that particular limit is over means contract is discharged, because law says that this is the limitation period. By breach of contract, if one party, he has breached or he has not fulfilled his agreement obligation, so that means he has breached the contract. Other party, he has the right to the court of law. That means here the obligation of B is over A, because A is the defaulter. Against him, he can go to the court of law. That means it understood that the discharge is, contract is discharged, and the second party has the power to go to the court of law to get his compensation. By material alteration, if in any contract you have changed something you have changed, amended, that can be called as that contract is over. That is contract discharge. Again, freshly you have to make the contract. Suppose you have made 1 year contract, and in 11th month you are changing it, altering it to 24 months. So that contract will be discharged. You can make a fresh contract for 24 months. Not that 12 month contract you will convert to 24 months. If you are making any alteration, that will be, the contract will be over. These are the various modes of discharge of contract. Is it clear, or any doubt in this? So this is one of the important question again. What are the modes of discharge of contract? Is it clear?
Yes, sir.
Yeah. How will we? One is by performance. If you are performing the act, both the parties, it's discharged. Consent. Both the parties, if they are giving consent that we are closing the contract, it is here closed. Now we are both the parties consented to stop the contract. That means contract is discharged. By impossibility, if due to natural calamity or something, it is impossible, then contract is discharged. Lapse of time, after particular time period, suppose 1 year contract you have written, that the moment 1 year is over, the contract is discharged. Then operation of law, if law says that something, some limitation or something, law states that once the time period is over, that means contract is discharged. Breach of contract, if any of the party, he breaches the contract, that case it can be understood that the contract is discharged, then other party can go to the court of law. The material alteration, if you are changing something, then also it will be called as discharge of law. These are the various modes of discharge of law. Now, the another question comes, what are the remedies for breach of contract? Suppose somebody breaches the contract, and what are the remedies? You can see parties to a lawful contract are bound to perform their respective obligations. Once you have made the contract, both the parties are bound to do their obligation. Whatever they have agreed upon, they are supposed to do. Based on the agreement, both the parties are liable to do their activities or do their obligation. If any party fails, that means it is a breach of contract. One of the party repudiates the contract by refusing to perform his obligation. He is said to have committed breach of contract. That means one party, he refused. No, I will not give now. You have paid. Suppose the agreement is made that I will pay 1 lakh rupee. You have to give this particular car to me. So after that, you say that no, I will not give the car. First agreement is made, everything is done, and advance is being paid. Later on, you are not accepting to that one. That means you have breached the contract. In case of the breach, the aggrieved party is relieved from the performing his obligation. That means, as we said, that discharge of contract happens when any of the party breaches to the contract. That means contract is ceased now. Once one party refuses to do, that means there itself contract is ceased. Contract is over. It is discharged. Now the other party, he has the right to go to proceed against the party at fault. So in case of breach of contract, the law provides remedies to the injured party as follows. What are those? Cancellation or rescission. So contract can be cancelled, or it can be time being, it can be stopped. Then restitution. In that case, if anything happens, then you can go to the court of law, and the remedies can be given by the court of law, or compensation has to be paid by the other party. Specific performance. Court may give the order to give the particular person to do the specific act. Whatever it is supposed to do, court can give order to the party. If he is refusing to do, then court can give the order, you have to do particular things which you have promised. If he is not paying, then he has to pay the compensation. Like injunction, here court can give order to someone who is breaching the contract. In that case, the injunction can be given by the court. For example, simple example I will give. Suppose a film star, he has made a contract with the particular director that I will act for this movie, and this duration I will not do any other movie. Suppose he, by this time, he has made the agreement, but he has signed for the another director also simultaneously same time. In that case, the aggrieved party, he can go to the court of law. Law can stop him. He can the injunction means he can give a summon to that person and ask him to stop doing that kind of activities, because as per the agreement you are not supposed to perform in under any other director. So in that case, court can stop him. Similarly, damages. Court can give order to pay the damages caused by the party. There are again various kinds of damages: special damage, specific damage. So several kinds of damages are there. As per the particular situation, the court can give order to the aggrieved party, order to the one party to pay to the aggrieved property damages. Quantum of merit. Based on that quantum of merit, how much in between, suppose contract has been declined by the someone, the whatever as per the merit, whatever he is supposed to, whatever the work is left over, and what are the compensation is to be, suppose for that amount the other party is supposed to pay to the aggrieved party. So that is called as quantum of merit. So these are the breach of contract. Suppose sometimes question may come, what is the breach of contract and what are the remedies for breach of contract? So it will be one question. The other one is, what are the various modes of discharging of contract? So details you can go through your study material also. So we have only 6 classes. So in that we have to complete, and there is another unit like company law. It's a very big unit. So we need to have some more time in that one. Shall we proceed further? By this, unit 1 is over. We can move to the unit 2. Unit 2 is small one. We can this is here we have partnership and sales and goods act. Quickly we can finish this unit also. Is it all right?
Yes, sir.
Yes, sir.
Yeah. Next is essentials of elements of partnership. Short question comes. What are the essential elements of partnership? Here, as it is very popular, all of you know what is partnership, but still. So what are the essential elements of partnership? Association of 2 or more person. There has to be minimum 2 or more person. They should associate together. Existence of contract. There has to be contract between the 2 or more persons. Carrying on a business. So all of them, they should start a business. Sharing a profit. And they should share profit with each other. Prevalence of mutual agency. So everyone is the agency to each other. So everybody is the part of the contract and everybody is responsible for the activity what is being done in the partnership firm. So what are the ingredients? Essential elements. It's an association of 2 or more persons. There has to be existence of contract, carrying on business. If you are making a contract and there is no business, then there is no partnership. So it has to be some business has to be there. Sharing of profit. So all of you, all the partners should share profit. And prevalence of mutual agency. Everyone will be responsible for the other party, who is dealing with you. If you are making, if you are the defaulter, all of the party will be responsible for it. So agency and master, I think in syllabus later on we can discuss what is agency, who is master, who is the agent. So it is there in further we can discuss. So prevalence of mutual agency. So every individual is the responsible for the activities. So these are the basic ingredients. Next is kinds of partners. There may be different kinds of partners in a partnership firm. The important classification of the partners is in below. Actual or active partners. They are the actual partners or active partners. Dormant or sleeping partner. One of the partner may be dormant. She may not be doing anything, but he is the partner to the firm. He is sharing profit, but he is not doing any activities in the firm. So that can be called as dormant or sleeping partner. Nominal partner. So nominal partner who are supposed to pay how much, who is responsible for how much, or all the partner, they have liabilities. So they have to pay or they have to share capital. Partner in profits only. Some partner may be in profits only. Suppose where a minor is involved. Making contract with a minor is not, it's not a valid contract, but the guardian of minor can make a contract on behalf of guardian, on behalf of minor. But in this case, he will be sharing profits only. He will not be, minor will be sharing profit, but he will not be held responsible for the any loss. Only he will be sharing profit. Sub-partner. Sub-partner in the sense, if your partner have led to given to partnership to someone else, so they are called as sub-partner. Partner by estoppel or by holding out. By court of law, if somebody is given order that he is the partner of the company, in that case, he will be the partner. These are the various kinds of partners. These are the minimum questions comes in the partnership act. So I have not taken much slides for this partnership. Next is sales of goods. We'll focusing more in company law. These are the small acts. Next is contract of sales of goods. So a contract of sales of goods is a contract whereby seller transfer or agrees to transfer the property in goods to the buyer for a price. So it is a typically buying and selling process. So contract of sales means a contract of sale of goods. There has to be sale of goods whereby the seller transfers the property to the buyer with a exchange of price. So that is the definition says by the section 4.1 says a contract of sale of goods is a contract whereby the seller transfer or agrees to transfer the property in goods to the buyer for a price. This is the definition. You cannot change it because this is the section. It is given by the law. Completely, it is a definition of contract. If you are changing, altering something, it will not be a full definition. So, in a contract of sales of goods, two parties, there has to be mutual consent. Transfer of property has to be there. Goods means any kind of movable property. Here, there are two kinds of property. Here, two parties. One is buyer and seller, another is buyer. There is a mutual consent. Just the presence of two parties is not sufficient. The parties must agree on the transfer of property. The parties say, if you pay this much, I will give you the product. So there has to be exchange of things for the product. So the parties must agree on the transfer of property. Transfer of property, what a contract of sale stipulates is the transfer of property, that is the ownership of goods and not the possession of the goods. The ownership has to be transferred. Only if he has taken the product, it doesn't mean that. When you are giving the receipt or something, some proof, delivering and giving the ownership to the buyer, that means it is a transfer of property is over, sales of contract is over. Goods means every kind of movable property other than actionable claim and money. For money, it will not be considered as sales of contract. Or any immovable property like your land or buildings, such kind of things, it will not, for immovable property, it will not be considered as sales of goods. It is only for the movable property. Price. Under a contract of sale, property in the good is transferred to the buyer for a price. There has to be some exchange of money. That is called as price. Price is the money consideration for the good. Then another ingredient is varied agreement as to delivery and payment. The contract may provide for the immediate delivery of goods or immediate payment of the price or both. So there has to be, there is a requirement, contract may be provide the immediate delivery. Once the product is delivered to your, suppose we have bought a refrigerator. Once the refrigerator is delivered to your house, you are supposed to pay money to the delivery person. So immediately it has to be exchanged. So if there is a requirement, that has to be completed. So requirement requires no formality. There is no formality, more formality is required, absolutely or conditional. It is the sales of goods act is absolute and conditional. If the condition is made, the property is delivered to your house, then only you will pay. Or sometimes if it is at the point of purchase, it has to be paid. So as per the terms and conditional, you have to perform the duty. These are the essential elements of a contract of sales and good. These are the two small unit act. The third unit is Negotiable Instrument Act. Have you heard about negotiable instrument? Anybody has heard about negotiable instrument?
Yes, sir.
Any example? Can you give me? Many of you might be working in companies or corporate sectors. There will be negotiable instrument you must have heard. And day-to-day life also, you people are using, making negotiable instrument. Any example?
Your salary.
Bank.
No. Sir, negotiable instrument is that particular instrument which there is a promise to pay some amount of money or currency, any other currency, to the others regarding the paid of dues and otherwise.
Yeah, that is one kind of negotiable instrument, which promissory note. That is called as promissory note. You must have seen that some of the printed. I promise to pay this much amount of money to the holder of the particular instrument, isn't it? That is called as
Check, sir.
promissory note. Anything else?
Sir, day-to-day bills. that we get.
No.
Check, sir. Check, sir.
Yeah, all of you must be using check. That is also negotiable instrument. Okay. When you present the check to the counter, then counter person, he will be paying you money. Another is bill of exchange. So we'll discuss each one of it. Now this Negotiable Instrument Act, it is 1881. The law relating to negotiable instrument is primarily contained in the negotiable instrument. This is a separate special act. So you will not mix with the Banking Regulation Act. RBI Act is separate. BRA, Banking Regulation Act is separate. Negotiable instrument is separate. So specifically, this is dealing with the this bill of exchange, promissory note, check. A negotiable instrument is essentially an instrument of credit. So once you present the negotiable instrument to the holder is submitting the negotiable instrument, the other party is supposed to pay you. So a negotiable instrument is essentially an instrument of credit, readily convertible into money and easily delivered from the one person to another. So when you present the negotiable instrument, it will convert to money and easily delivered from one person to another. For example, if you are presenting a check, immediately the money has to be paid to the holder of the check, and the check can be transferred one person to another. The word negotiable means transferable from one person to another, because it is negotiable. It is transferable from the one person to another. And the term instrument means any written document by which a right is created in favor of some of the person. Because it's their check is a written document. You are writing there, pay to so and so amount of this much. So the banker, they are paying based on the name placed in the check. Negotiable instrument is a document by which rights vested in the person can be transferred to another person. So the right is vested to the person holder of the check, and it can be transferred to another person in accordance with the provision of the Negotiable Instrument Act. In some of the cases where it is not supposed to be, in that case it will be restricted. Otherwise, normally it will be transferable. The Negotiable Instrument Act does not affect the provision of the Section 31 and 32 of the RBI Act, Reserve Bank of India, 1934. In 31 and 33, something special, it is given by the Reserve Bank of India. It will not affect, negotiable instrument will not affect Section 31 and 32 of the Reserve Bank of India. That is special act, and it has to be as it is to be followed. Now, what are the salient features of negotiable instrument? Freely transferable. As we seen in the definition, it's transferable from one person to another. It is easily freely transferable. Defect-free title to the transferee. There should not be any defect in title. So clearly, it should be mentioned the name of the person who are to be paid. It is to be transferred. Money is to be transferred to whom? Recovering. You can recover. Ceiling on transfer. There can be put a ceiling limit of the transfer. Payable to order. It is order to pay to so and so holder of the check. Payment. There has to be a payment. Presumption. Presumption will be made. It is mentioned in the document that after this many days or on so and so date. So whatever it is mentioned, based on that, it has to be paid. What are the kinds of negotiable instrument? As we discussed, bill of exchange, promissory note, and check. These are the three kinds of negotiable instrument. Now, let us see what are the three kinds of instrument. What is bill of exchange? A bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain amount of money only to the order of a certain person or to bearer of the instrument. It is a written document, and it gives the unconditional order to the banker or third party to pay the holder of the negotiable instrument. Okay. You can see the definition. Bill of exchange is an instrument. It is an instrument. It is in writing. It should give unconditional order signed by the. Now we'll see that what is the difference between promissory note and bill of exchange and check. So bill of exchange will be in writing. Unconditional order should be there, signed by the maker. Maker has to be signed, directing a certain person. He has to direct the other person, third party, to pay a certain amount. He should say that the holder of the check, what are the amount to be paid, this much amount when it is presented to the third party. Certain sum of money only to the order of a certain person or to the bearer of the instrument. When the bearer of the instrument, holder of the instrument, he presented the negotiable instrument to the third party, there is an unconditional order by the maker to pay this holder of the instrument. Next, we'll see what is promissory note. A promissory note is an instrument in writing. This is also instrument in writing. Negotiable bill of exchange is also instrument writing, and promissory note also instrument in writing, but not being a bank note or currency. If it is a bank note or currency, it is not promissory note. Containing an unconditional undertaking. Here you can see in case of bill of exchange, unconditional order, but in case of promissory note, it is unconditional undertaking. What is that? I promise to pay. I undertake. That means individual is promising to pay certain amount when you are presenting the instrument to me. A promissory note is an instrument in writing, not being a bank note or currency, containing an unconditional undertaking signed by the maker. There also signed by the maker, here also signed by the maker, to pay a certain sum of money. Same there also, here also, only to the order of a certain person. Same for promissory note, bill of exchange, or only to the bearer of the. In these two cases, here it is an unconditional undertaking, there it will be an unconditional order. Here third party, the order you are giving to third party. Here unconditional second party, he is taking the unconditional undertaking. I promise to pay. When you submit the check, it will be written in that promissory note that I promise to pay this much amount of sum once it is presented to so and so date. So if it is mentioned, then it is a promissory note. Now let us see check. A check is the usual method of withdrawing money from an account with a banker. All of you must be using check. It is the usual. When you sign a check and present to the counter, they will be giving you money. A check, in essence, it is an order by the customer of the bank, directing the banker to pay and demand. So what you are doing, you are the customer of the bank, and you have some money in the bank. You are using the check and you are giving order to the banker to pay to the holder of the check the specified amount, or to the order of the person named there onto the bearer. Either to the name you are mentioning the name, you pay this much amount to so and so person, or the holder of the check, you are signing at the front and back and giving the check to the someone to get the money, and it is a order given to the banker to pay a certain amount. Is it clear? Bill of exchange, promissory note, check, these are the three kind of negotiable instrument. Now we'll see the difference between promissory note and bill of exchange. What is the difference between promissory note and bill of exchange? You can see there are only two parties in promissory note, because you say that I promise to pay. There are two parties, the holder and the debtor and the creditor, to whom to be paid, and the maker of the instrument. There are two parties. In case of bill of exchange, what is there? There are three parties: drawer, drawee, and the payee. You are giving unconditional order to the someone, third party. So there are three parties. One is the drawer, who make the instrument, drawee, who is holding the instrument, and the payee, who has to pay, the third party. So in case of promissory note, you can say contains an unconditional promise Here in promissory note, you promise to pay. So there are two party and unconditional promise is there by the maker of the instrument. In this case, bill of exchange, you can say contains an unconditional order. Here promise, there order. Order to the drawee to pay according to the draft direction. In case of promissory note, no prior acceptance is needed because directly you are dealing with the second party. There is no prior order is to be taken or acceptance is to be taken. But in case of bill, after sight must be accepted by the drawee or his agent before it presented for payment. You have to discuss with the third party to pay. If after sight, so afterward it is being presented, then there is to be third party is to be consented. In case of promissory note, liability as the maker or drawer is primary and absolute. But in case of bill of exchange, the liability of the drawee is secondary and conditional upon non-payment by the drawee. If it is not paid, then in that case, there is the as per the law, it has to be moved. But in case of promissory note, liability of the maker or drawee is primary and absolute because there are two parties. So it is primary and absolute. But in case of it is a conditional. What condition you have mentioned in the agreement with the third party? As per that only it will be regulated. In case of promissory note, no notice of dishonor need to be given. If you are dishonoring the promissory note, so there is no need of notice to be given. You can directly go to the court of law and take action. But bill of exchange, notice of the dishonor must be given by the holder to the drawee and the intermediate endorser to hold them liable thereon. You can give the notice to the individual who are defaulter. You can give the notice. So these are the few difference between promissory note and bill of exchange. I hope it is clear to all of you what is promissory note and what is bill of exchange. Is it clear?
Sure.
Yes, sir.
Shall we proceed further, or if any doubt you can ask, because hardly a few minutes are left, about 2-3 minutes. You can ask question anything or any doubt, or we'll discuss then one more.
Any specific format for writing, sir, for bill of exchange and promissory note, or any documents, standard documents?
Yeah, that you can see there are various kinds of, even you can make that I promise to pay, like promissory, I promise to pay so and so. Like there are various formats are also there. So you can see those formats. It cannot be shown here. I do not know. Here also there is no format is given. And I'll see if possible next class I can show the copy of those things. But it's from, or any one of you are dealing with such things, you can next time you bring it so that all of you can be.
Do we require any stamp paper for bill of exchange and for promissory notes?
I don't think stamp paper is required. It is
No, stamp paper is required.
You have to.
Stamp paper not required.
You have to sign the promise. The person who is making the promissory note, he has to sign and give the unconditional order, and there is a third party's name also, with all the official seal or designation. Everything is to mention and can make a order. Sometimes you must have seen some companies giving advertisement. I promise to pay this much amount of money to holder of this J. During advertisement, if you are buying something, if you are carrying that particular cutting the piece from the newspaper and submitting to the seller, they will be giving you a discount of this much or like that. I have seen
yes, something like that is like that.
Yeah. So like this promise, anything can be. It is unconditional order or unconditional promise you are giving. So if you are failing to that, you are no need of stamp paper. I don't think any stamp paper is required. In some cases, it may be. I'm not aware of it. So where a higher amount of money will be involved or something, There may be some provision, but normally it is not. Generally, these are the differences. Okay. And among you, among all of you, if somebody is advocate dealing with such type of things, that they might be knowing, and they can also give some insight. They are most welcome. If somebody is there who is knowing all these things, we are not practicing advocate or something like that. We are just theoretically we are teaching, and day to day there are a lot of changes going on, and those who are practicing, they might be knowing better. Any one of you are advocate here? Or practicing such kind of things like legal officer in some of the corporate sector, they also are dealing with such type of documents. Okay. So next class we'll be discussing a little bit revision we'll do in this one, and then most important is next is company law. It's a very big chapter. So at least 2 to 3 classes is required. Then there are other things, and we need to discuss the old question papers also.
So please share.
Will you share this PDF?
Yeah, once the class is over, I'll share. Not today. At the end of the class, I will share the PDF, this PPT to all of you, so you can make use of it. Okay.
So how will it be shared? Just through mail ID or what?
So through mail only we can be.
Okay.
So some of you can give your mail ID to me, so I can to you, so you can share among yourself.
So it would be good if you share now, because so that
will be helpful. So the exams are near. That's all.
Just 10 days.
If
Can I share my mail ID here, sir?
If immediately I share the PPT, then there you may not be much interested, or sometimes you will be thinking that
No, not like that. Definitely
PPT
not
is
like
there.
that.
What is the need of class? We need
No. Definitely not like this. We just
next class we'll share. Don't worry.
Okay, sir. Sure.
Next class, at least half of the paper, let it be over.
Okay.
So I'll share it. So you'll have some 8 to 10 days. You can prepare.
Yeah.
Okay.
Okay, sir. Thank you.
So what I insist, first of all, you need to go through the study material at least. So whatever it is discussion being taken place, you kindly go through the study material. Then afterwards, when I give the PPT, you can make use of it.
Okay, sir. Sure. Thank you.
Okay. So I request all of you to join tomorrow. I'll be joining at 12 to 1. Okay.
Okay, sir. Thank you.
So we'll be discussing about company law and leftover topic of this one. Okay. Any doubt? If you have any doubt or any clarification in between, you can stop me and you can ask also. So that's what I have not muted all of you. We have left it like that. You can discuss in between. Okay. Thank you very much. See you next class again tomorrow. Tomorrow 12 to 1. Okay.
Okay, sir. Thank you.
Okay, sir.
Right. Thank you.
So what class do we have next?
Hello, good evening, all of you.
Good evening, ma'am.
Good evening, ma'am.
Hope you're doing well.
Yeah, doing well. After the storm, we are able to get at least connectivity back. Just one second, I am uploading the PPT, right?
Sure, ma'am.